and thank you for joining us today. My name is Michaela Vrazdova, and I'm a Senior Associate at Scott Legal PC. Today, we are going to spend some time and talk about how you can obtain an employment-based green card in the US. A few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals pursuing various types of visas and green cards. We can assist you with anything from employment-based, family-based, and investment-based visas and green cards. And we regularly process a high number of different employment-based green card categories. We'll continue to have this webinar series, and we will do at least 2 webinars a month on different immigration topics. At the end of this webinar, we'll send you out a few things. We'll send you the PowerPoint we'll be using during this presentation. We will send you a comprehensive visa guide that goes over the different employment-based green cards. And we will also send you a link where you can sign up for additional webinars we will have in the future, and also a link where this webinar will be made available. This webinar will also be posted to our YouTube channel, and we encourage you to subscribe and hit the notification button at our YouTube channel, as we often post new immigration videos. We will also send you a link where you can set up a consultation with one of our attorneys to discuss your particular situation. Today, we are lucky to have Kelly Weiner, who is our managing attorney and who will be a speaker. Kelly has a vast experience with all employment-based green card categories. And as I mentioned, my name is Michaela Vrazdova, and I'm a Senior Associate at Scott Legal. Finally, if you have any question as we go through the presentation, please feel free to put it in the chat box or in the Q&A box, and we'll get to all questions at the end. Kelly, so why don't you tell us about the different employment-based green card categories?
Thank you, Michaela. Perfect. So we're going to focus today a lot on kind of the PERM process, but we also just wanted to start the presentation by kind of briefly discussing, some of the other employment-based green cards. So there's, many ways to get, kind of a green card in the United States. And for the employment-based categories, we have the EB-1A. So this is for people with extraordinary ability who've risen to the very top of their field. EB-1B, so outstanding researchers and professors. EB-1C, so people who are multinational managers or executives. And EB-2, advanced degree or exceptional ability. So this can be sponsored through the PERM or can also be sponsored through the National Interest Waiver. The National Interest Waiver is kind of a specialty category where you can waive the requirement of the PERM. As I mentioned, also the PERM is a part of that. Then the EB-3, so this is through the PERM, so company sponsorship. This is for professionals, skilled and unskilled workers. EB-4, we're not going to really spend time on. This is a specialty category for kind of a few different types of visas, of green cards. And then there's EB-5. So this is, investment-based. So people who are investing a certain amount of money into the United States and then creating, 10 full-time U.S. jobs. And this can be done either through, direct investment or through a regional center. So someone had commented about the sound. I believe that I was able to hear Michaela and she's able to hear me. So, we maybe, log off and maybe log back in. Perfect. So, all right. So what is the labor certification process? What is PERM? All right. So PERM, as mentioned in the previous slide, is, through EB-2 and EB-3. And the PERM process is a process where a U.S. employer is going to sponsor somebody, for a permanent, green card in the United States. So this allows you to live and work in the United States permanently and eventually to apply for U.S. citizenship if you choose to do so. So the PERM process is really what I'd say a 3-step process, from the very beginning up to the time of actually getting your green card, having that green card in your hand. So the first step in this, which is really the longest step, is the actual PERM. And we'll talk a little bit about what's involved in that on this slide. Then the second step is the I-140. So that's a petition that's filed by the company that show, basically where they say, here's the proof we can pay the prevailing wage, here's the details of the job, and here's the proof that the employee applicant, meets all the qualifications. And then the last step is the I-485, which is the green card. This can also be done through something called consular processing, where you get your green card at a U.S. consulate abroad, and we'll talk about that a little bit later. So for the PERM, there are kind of multiple steps to this. I'd say the first step really is you're going to draft a job description. For PERM, you're only allowed to, the company actually has to draft a job description that is what we call PERM compliant. And really what that means is that they can only ask for the minimum requirements to do this job in a reasonable manner. So in a normal recruitment process, many companies are going to ask for things like, great team player, good listener, kind of more subjective requirements. So for the PERM, you really need to, focus on, the job description needs to be updated to focus on kind of more objective requirements and just thinking about what are the actual minimum requirements to do the job in a reasonable manner. Once the job description is drafted, then the company can go ahead and file a prevailing wage determination. So this is a document that's filed with the Department of Labor, where the Department of Labor will assess what are the job duties, what are the job requirements, what is the location of the job, or multiple locations if the job, requires travel or requires, the person to kind of go to multiple different work sites. And then they'll issue a prevailing wage determination. And then the company, is required to pay at least that prevailing wage or higher at the time that the person gets the green card in the future. So once you have the prevailing wage, and the company is confident that they can move ahead with that wage, then the company will start the recruitment process. So this process is where the company needs to test the U.S. labor market. And this involves them placing advertisements and where they can place the advertisements and what mechanisms they have to use are kind of specified in the regulations. So if this is a job that's not a professional job, so not a job that requires at least a bachelor's degree or higher, then you only need to do kind of 3 mechanisms of recruitment that are specified in the regulations. If it's a job that is a professional job, so requires, at least a bachelor's or higher, then there's kind of 6 recruitment mechanisms that the company has to undergo. So the recruitment process takes at least 60 days, by regulation, usually closer to maybe 75. As towards the end of the process, the company has to gather all the resumes, all the proof of the, interviews they've conducted, and they can only proceed at this point if they've conducted recruitment and then they've determined there are no willing, qualified, and available U.S. workers. So if during this recruitment process, a willing, qualified, and available U.S. worker applies for the position, or a worker who, could be trained, through a reasonable period of on-the-job training, then the company, the recruitment process does have to stop. The purpose of this process, and this program is that the government wants to ensure that if there are willing, qualified, and available U.S. workers for the job, that the company is not hiring somebody, from outside the United States to do the job. So if the company completes recruitment and has not found any willing, qualified, and available U.S. workers, then it will work with the attorney to prepare an audit file, so proof of all the advertisements they placed, proof of everybody that they interviewed, and other documents, kind of supporting the application process. And then they will go ahead and file the labor certification. The labor certification can either be certified, so that means it's approved and you can move ahead to step 2. It could also be denied, or it could be audited. So if it's audited, then what this means is that the Department of Labor is going to ask for more information, and they will want that more information to be provided within 30 days. So this is where the company will have to provide proof of the recruitment it conducted, proof of the resumes and, people that they contacted during the recruitment process. Additionally, if there are any requirements that exceed what is normally required. So for example, if the job requires a foreign language, if there's requirements outside of what's normally, required for the occupation, then the company will also have to submit what we call business necessity documentation. So this is where the company is going to have to specify through, usually a memo and then supporting objective, documents as to why the requirements are, truly necessary for this type of position, even though it's outside what the Department of Labor considers to be normal. So just because you have, a foreign language requirement or requirements outside what's normally required, it doesn't necessarily mean the case will be audited, but it makes it more likely that the case could be audited. And if it is audited, you'd submit an audit response within 30 days, and then ultimately they will make a decision as to whether the case will be certified or whether the case will be denied. At this time, in terms of, when we're talking about timing, at this time, the PERM process itself is taking quite a long time because prevailing wages are taking somewhere between 6 months to sometimes up to 12 or even 13 months to come back. Recruitment itself takes about 2 to 3 months. Then once the labor certification is filed, that's now taking around 9 or 10 months, maybe even a little bit longer. So these timelines will fluctuate. They have fluctuated, over the years, sometimes have been much lower, sometimes have been a bit higher. So always something to kind of discuss with your attorney at the time that you're starting the process, but just know that the timelines can change. But generally, you're looking at a timeline of years, not months, when you're looking at the PERM. So once we've made it to kind of the I-140 stage, the second stage of the process, at this point, the company is going to file this I-140 form outlining the details of the position. They'll also include proof that they have the ability to pay the prevailing wage. So they have to include documentation showing that from the time the PERM was filed up till, now this time when they're filing the I-140, that they have had the ability to pay the prevailing wage. So usually this is going to take the form of audited financial statements, tax returns. If the company has more than 100 employees, then a financial officer may be able to write a statement, showing that, that the company has sufficient funds. Also, if the applicant is already working for the company and being paid the prevailing wage, you can also include that proof to help support this argument. And then as well, during the I-140, you would need to include proof that the applicant themselves meets all the requirements on the PERM. So for example, if the job description said you need, a bachelor's degree in graphic design and 2 years of experience as a graphic designer, the I-140 petition would need to include proof of that degree and proof of that 2 years of experience, usually in the form of a detailed employer experience letter from the prior employer. Also important to note that experience has to, have been gained prior to the applicant joining, the company that is sponsoring the PERM. So as a general rule, you're not allowed to use experience that you gain with the sponsoring employer unless, the job in which you gain the experience is, not substantially comparable to the PERM job. So the jobs would need to be significantly different. So that's, I'd say, kind of another audit trigger if you're using experience gained with that sponsoring employer, and you can only do so in very specific circumstances. So the I-140, the good news about the timing is you do have the option to pay an additional $2,500 to get an answer on this within 15 calendar days. So this is really the only part of the 3-step process where you can really expedite it. So once you have a response on that, or if an immigrant visa is available, then you can proceed with the green card part of the application. So, if you're in the United States and your I-140 has been approved and there's an immigrant visa available to you, so that means the EB-2 or EB-3 categories are current, then you can go ahead and file your green card application. You can also include on your green card application, if you are here with your spouse and any unmarried children under 21, they can also file their I-485 forms along with you as dependents on your application. And if you are outside the United States, or for some reason you want to do consular processing, then the case would get sent, we'll talk a little bit more about this process later, but the case would get sent to the consulate, to continue that process. In terms of kind of the timing, just going back a bit to whether the immigrant visa category is current or not. For example, right now, the categories are all delayed. So this means you could get to the I-140 stage, have an I-140 approved, but really not be able to proceed yet because the number of immigrant visas available has been used up. Or for example, people who were born, in India or China may have kind of longer delays or backlogs. But then sometimes the entire, worldwide, the category is backlogged, right now. So, it's something just to keep in mind in terms of your timing, that you may not be able to proceed immediately to the green card part of the process after your I-140 is approved. All right, so let's talk a bit more about the green card process and the differences between adjustment of status and consular processing. So let's say that you are in the United States, you live in the United States full time, that's where, kind of you're working and your whole life is there and your family is there. So in this situation, a lot of the time, the thing that's going to make the most sense is to go for an adjustment of status. This is where you file Form I-485 with U.S. Citizenship and Immigration Services. It gives you the ability to remain in the United States for as long as this application is pending. Also, you're able to apply for work and travel authorization, and that includes your dependents. So when you file for your, your spouse and your children, file for their I-485s, they can also file for that work and travel authorization. One kind of downside to an adjustment of status is that if you're not on H-1B or L-1 status, then once the adjustment of status is filed, you cannot travel until you get that travel authorization approved. So that is something to keep in mind. If you're kind of getting ready to file your adjustment of status application and you have international travel, coming up, you really want to discuss that with your attorney to make sure that you have some type of plan. As I mentioned, H-1B and L-1, visa holders, there's some exceptions for them where sometimes they are able to travel while the adjustment of status is pending without abandoning it. But for many other people, for example, let's say you're on an E-2, and you filed the adjustment of status application, you cannot travel until your travel authorization is approved, and that can take several months. If there's an emergency, if a family member is very ill, you need to attend a funeral, there is an ability sometimes to apply for an emergency travel document. It's not a right that these are granted, but you can try. It's just, discretionary whether the officer will grant it or not, but just a good thing to keep in mind. So once the I-485 is filed, it will go into a processing queue. Our general experience is that it's taking, several months, even up to and over a year sometimes. Many applicants will also have an interview with the USCIS officer. Sometimes it is approved just on the papers without an interview, but that's really at the discretion of the field office. If you do go to an interview, you're generally going to be asked to bring kind of updated proof, of the job offer, that you're still working for the company. And then they'll also at the interview ask you questions about your history. If you've had any arrests or criminal issues, that will all be discussed. Anything that could flag you as potentially being inadmissible. Generally, you're going to want to discuss that with your attorney ahead of time, so there's no surprises at the interview. And then if the application is approved, then you will receive your green card in the mail. The other option for getting the green card is something called consular processing. So, some people, there may be a situation where perhaps, the person just travels for business constantly. They're not on an H or an L, and they just cannot wait in the United States for this travel authorization for several months. Other situations, perhaps, they perhaps kind of you were on an H-1B and you ran out of time and you are now working remotely or working abroad and you're not in the United States. In those circumstances, sometimes just because of personal preference, there's also the option to do consular processing. So when you file your I-140 petition, you would indicate either you're doing an adjustment of status or you're doing consular processing. If you indicate consular processing, then once the I-140 is approved, it will be sent to the National Visa Center. Then you will pay an immigrant visa fee. You'll submit what's called the DS-260, and you'll submit supporting documents to the National Visa Center. So these are your birth certificate, police certificates from places you've lived, supporting documents for your dependents, marriage certificates, things like that. That will all get sent to the National Visa Center. They will review the documents. Once they determine that you've submitted everything that they have requested, then they'll send the file to the U.S. consulate for processing. Then the consulate will schedule you for an appointment. You will go to the consulate and attend the appointment. You'll also have to attend a medical exam prior to the appointment. And then, if the application is approved, they'll collect your passports and put an immigrant visa stamp in there. You will then need to enter the United States while the immigrant visa stamp is valid. They'll also usually give you an immigrant visa, what we call a packet, like a sealed packet. You'll bring that with you. And then once you enter the United States, a Customs and Border Protection officer will inspect you, will put what we call an I-551 stamp in your passport. And then you'll be able to enter the United States and should receive your green card within a few months after entry. So let's talk about who can pay for the green card fees. The fees related to the PERM process, the legal fees and other related fees, for example, if you have to place advertisements and there's fees for that, all of that has to be paid by the sponsoring employer. The employee is not permitted to pay, for these fees. For the I-140 immigrant petition and the green card petition, these can be paid by either the employer or the employee. So, that's definitely something, people can discuss with their employers. Many employers will have, especially larger employers will have kind of very specific policies in relation to this. But it is important to know, on both sides that an employee should not be paying, cannot be paying the legal fees and other fees related to the PERM. So now I'm going to ask Michaela to talk a bit about dual intent.
Yeah, thank you, Kelly. So there are two concepts in immigration law, or two categories which non-immigrant visas can fall under. So one is a non-immigrant visa, or kind of like a single intent visa, and the second one is a dual intent visa. So most of the non-immigrant visas do not allow for the dual intent, and they are basically only a non-immigrant visa. So this means that when you are applying for these types of visas, you have to show that you have strong ties to your home country. You have kind of like a residence there, and you do not plan to reside in the United States permanently. Some of these visas, like for example, when you are applying for a B visa, you have to show really strong ties to your home country because that's only like a tourist visa. On the other hand, if you are applying, for example, for a TN visa, E1, E2 visa, those are still all, like non-immigrant single intent visas, but the standard, like what you need to show for those types of visas is kind of lower. So for example, you don't necessarily have to show that, you have a residence abroad, but you should still be able to point to some ties to your home country. And those, those categories are not, as I mentioned, for example, TN, E1, E2, those are not dual intent visas. So now the advantage of the dual intent visa is that, those visas basically allow you to have intent to reside in the US permanently. So these are, as Kelly mentioned previously, H-1B visa, L-1 visa, and O visas are all dual intent visas. And this means that, you can be in the United States, for example, on an H-1B visa, And at the same time, you can have a green card application pending, and you can kind of still travel internationally. You can even renew the H-1B visa at a consulate or with USCIS, and it would still be renewed, even if you have the green card application, which is a permanent residence application pending. So that's a huge advantage if you are in the United States in one of those visa categories, H-1B L1 or O1, because you know it kind of like allows you to maintain that underlying visa status, but also you can have the green card application pending at the same time, and you will not have you know, kind of like issues renewing the visa. And if you are in the US on H-1B or L1 visa, you can even travel internationally while your green card application is pending. Perfect. So now let's move on to, you know, like what you should keep in mind when you are moving from a visa to a green card. So you know, you should definitely keep in mind you know, like what's your underlying status in the United States, and how much time is left on your current status. So, you know, the visas that I mentioned that are single intent visas, you know, you will have kind of like difficult time renewing them if the green card application has been filed. So let's say, for example, that you are in the United States on a TN visa, and then an employer files a green card petition for you, you know, then it would be really difficult for you to renew the TN visa after the green card petition has been filed, because the you know, the CBP or the consulate would see that the petition was filed, you have intent to reside in the US permanently, and so you know, you have expressed that immigrant intent. So in these types of cases, you know, if you are in the US on one of those single intent visas, it's really important to kind of like discuss with your attorney, like when would be the best time to file the I-140 and most importantly, the I-485 portion of the application. So so that's definitely one thing to keep in mind, you know, like what's your immigration status, how much time you have left on that status. Now, another thing to keep in mind, as Kelly already mentioned, is, you know, like, are you currently in the US or are you abroad? So if you are in the United States, you can adjust status in the United States. The advantage is that you can stay in the US during the whole process as the green card application is pending. You can get the work and travel authorization. If you are kind of like, you know, like living outside the US and someone is sponsoring you for a green card, you don't, you know, you only have the option to kind of do the consular processing. But you know, so that will be kind of like the only option. Another option or another common example when people do the consular processing is when they, as Kelly mentioned, like when they need to travel internationally often and they just cannot afford to wait for the travel authorization for, you know, several months, like 6 to 12 months, then they often do consular processing. And then one last thing to keep in mind is, you know, like which family members do you want to include in your green card application? So you can include your spouse and then your unmarried children under the age of 21. So, you know, like let's say that your children are kind of like approaching the age of 21. You know, it may be definitely good to kind of like have a talk with your employer, or, you know, like some of the green card categories, you can file a self-petition. So in that way, you know, in that case, you would be able to file it yourself. But, you know, if your children are kind of approaching that age, you know, it's definitely good to kind of like have a talk with the employer or, you know, with an immigration attorney to kind of discuss, you know, like when it would be kind of like the best time to file, so your children can still get the green cards. Perfect. And now let's move on to, you know, like what happens at the green card interview. So in either case, like when you are filing an adjustment of status or when you are doing consular, when you are applying for a visa for the immigrant visa at a consulate, I would say in most cases you will have an interview at a consulate. You know, you will always 100% have an interview. If you are filing an adjustment of status, like we have seen some cases where there hasn't been an interview and kind of USCIS kind of like approved the application without an interview. But they can always schedule an interview. So it just, with USCIS, it will, you should always be ready that it will be an interview. You and your, family members will kind of like need to attend. So, before the interview, it's going to be important to review both the I-140 petition and the I-485 petitions that were filed with USCIS. In the I-140 petition will contain documents like, the job description, like more like information about the job you will be in the US, information about your education, qualifications. So for that part, you should just kind of like really be familiar with the job you will be doing in the US. The job duties, the officer can ask you about your kind of like previous work experience. So you should definitely spend some time and review the I-140 petition that was filed by the employer. And for the I-485 petition, that's the adjustment of status petition. You should also spend some time and kind of like review that. If you have any, like previous immigration violations, like overstays, unauthorized work, criminal violations, like anything like that, then, it's going to be important to kind of like discuss, those with your attorney even before the adjustment of status petition is filed. But also to just kind of like have a call before the interview. So, your attorney can best prepare you, like how to answer questions, about any kind of like violations or any, you have had in the past. As I mentioned, like all you and the family members that were kind of like applying with you will have to attend the interview. USCIS does want to see some original documents. So they will want to see the original marriage certificate and birth certificates. They just like look at them and give them back to you. But usually they want to see them at the interview. You will, if you haven't submitted the medical exam at the time you were filing the green card application, you will have to bring the medical exam with you to the interview. Let's say that you submitted the medical exam with your green card application, but you submitted your green card application a long time ago. You should just make sure that the medical exam is still valid, because in some cases you would have to redo and kind of like bring a new medical exam with you to the interview. You should also get updated proof of employment from the sponsoring employer, to just kind of show that you are still working for the same employer, you are still intending to do the job as it was described in the PERM and in the I-140 petition. You can also bring like 2 or 3 recent pay stubs from the employer just to kind of show that, yes, you are, like still employed there. And you should also bring proof of maintenance of status in the United States. So, this would most commonly be your I-94 form from the CBP website. If you, let's say that you have renewed visa since you submitted the I-485 petition, for example, you have renewed your H-1B L1 visa, you should also bring evidence of that to the interview. And as I mentioned, it's always good to kind of schedule a call with your attorney and do kind of like a practice interview, some practice questions before the interview. So, so your attorney can also let you know, like, what are some common questions, like how to respond to them. So that's always a good idea. Perfect. And now Kelly will talk a little bit about what is porting.
Perfect. Thank you, Michaela. So porting is, I think, something that's important to know about, because the PERM process is a process that takes several years, and often, during that time, careers are progressing, things are changing within companies and people's goals are changing. Like at many times in the PERM process, like let's say a company has agreed to sponsor you for a PERM and they've just started doing recruitment or something like that. If you change employers, you really don't get any benefit from that previously filed, previously started PERM. You kind of are starting from scratch. However, once you get to a certain step of the process, so once you get to the point where your I-485 has been filed and is pending for at least 180 days, then you can take advantage of something called porting. So, a couple important things to know about this. So one is that the I-140 that was connected to the I-485 does have to be approved before the porting request can be approved. So needs to, that needs to, actually be approved. If it's denied and your I-485 is pending, you can't kind of take advantage of porting. But if it has been approved or if it's pending and then is ultimately approved, then you get this great benefit where, you're able to actually port, go to a new employer, and that new employer does not have to complete a PERM or an I-140, for you. However, this new employment has to be in the same or a similar occupational classification as the job that was described in the form I-140. That's the basis of your green card application. So if your PERM was an I-140 were approved, as a finance professional, you're not going to be able to port to become, a wedding photographer, but if you're porting within your industry and, same or similar occupational classification, then you are able to make this change. Another important thing to consider is you are able to port kind of to any new, viable employer, including to self-employment. So, you would still need to show, that there's viable self-employment. You need to provide supporting documents, outlining what are the job duties, what are the wages that are going to be paid, where is the, kind of, they're going to look at various different things to prove that it's the same or similar occupational classification, and you'll need to submit that on something called Form I-485 Supplement J. But if, the officer gets that request and determines that, this is a viable job offer in the same or similar occupational classification, then it can be approved even if you're changing employers. So good thing to keep in mind if you have an I-485 that's, been pending and your I-140 is approved, or, you expect it will be approved. So another common question we get is about changing employers after you get your green card. So ultimately, can you change your employer after you get your green card? The answer is yes. It is possible to do this. However, when you obtain your green card, you are making a good faith attestation that you plan to continue working for the company that sponsored you, and the company also is making that attestation. So for example, if you got your green card and then the next day you quit, that's something that, in the future, if you go to naturalize to become a US citizen, they will look at your work history. They will look back at the underlying basis of your I-485 green card application. And if they suspect there was any type of fraud, based on any action, like really suddenly leaving your employer, that's something that could be problematic. Let's say you get your green card and a week later the company folds and fires you, that's not a problem. Ultimately, like, circumstances can change, and if you work for that company for a few months and then ultimately you get a better job offer, you are able to take that. You are able to leave. You're not tied to that employer. It is important to kind of discuss with your employer, because sometimes employers will have policies regarding, recouping certain fees if you leave within a certain time. So it really is important to kind of discuss that, kind of with, or understand the policies that are in place for your employer, before, making any changes like that. But yes, it is possible to leave your employer after you get your green card. But especially if you want to become a US citizen in the future, you want to be thoughtful about when you're doing that, and continue working for the US employer, ideally for, some period of time, several months, to ensure that there's no questions, when you go to naturalize about, whether you really intended to continue working for this company. So we've come to the end of the presentation. I see there's a couple of questions that have come in. Michaela, they're asking about if you're applying for an EB-2 NIW, can you still apply for the DV lottery? Would that be any problem?
Yeah, so you can still you can still apply. It would just kind of, you just want to keep in mind, like, for the EB-2 NIW, like, have you only filed I-140, like, or have you already filed the I-485? So it would just kind of depend, like, what stage that application is in. But like, generally you can file, you can apply for like different types of green cards, and that's generally fine.
Perfect. So someone's also asked about the EB-2 NIW process. If your home country is too busy, can you get an appointment from another country? So the way that this works, is that generally what they're going to do is base where your application is sent on the last country you were living in. So the last country where you were a legal resident and residing, that's generally where they're going to send the application. Let's say if while the application is pending, you move to another country, depending on what stage the application is, you sometimes can get them to change it to another consulate. However, you can't kind of change consulates just based on, oh, it's too busy. So like they won't kind of change it based on, your convenience or if something is too busy, but they will change it. If you have moved to another country, you're legally residing there and you can provide that proof to them, then, generally at that point, they are willing to kind of transfer the case. Perfect. So I think those are all the questions we have. So I will close here. Thank you, everyone, for joining, and thank you, Michaela, for sharing your knowledge. Have a nice day.
Thank you.